I found out my family's lake house was closing escrow in 12 days from a stranger's Facebook post. Not from my brother, not from my mother. From a woman named Christine Boyer, a real estate agent in Charlevoix, Michigan, who'd posted a listing photo. Our dock, our boathouse. The exact spot where my grandfather taught me to fish when I was 6 years old, with the caption under contract. Rare 6-acre Lake Michigan parcel, incredible development potential. I sat in my car in a Trader Joe's parking lot in Grand Rapids, staring at my phone, reading that caption 4 times, because the land in that photo had belonged, jointly in equal shares, to me, my brother Danny, my sister Carol, and our mother, Ruth, for 11 years, since my father died and left it to all 4 of us in his will. Nobody had discussed selling it. Nobody had discussed selling it because I would have said no, Carol would have said no, and my mother at 81, with worsening dementia that none of us had yet officially had a doctor put a name to in writing, could not, legally or practically, have made that decision alone. And yet there it was, under contract, 12 days from closing. My family's land, sold to a developer planning to bulldoze the boathouse and build 11 luxury condos, using a deed my own brother had filed at the County Register of Deeds 8 months earlier. A deed I had never signed, never seen, and never once been told existed. If you're new here, welcome to Family Hidden Fight, where we tell you the truth about the wars fought behind closed doors, inside families, sometimes with only days left on the clock before it's too late to stop them. Today's story is called The Deed That Wasn't Supposed to Exist. Let's begin. My name is Amanda Reyes. I'm 39 years old. I work as a middle school science teacher in Grand Rapids, and the property at the center of this story, 6 acres on the eastern shore of Lake Michigan, just north of Charlevoix, with a modest 4-bedroom farmhouse and a small boathouse my grandfather built with his own hands in 1962, has been in my family for 3 generations. My grandfather, Walter Reyes, bought that land as a young man, back when it was cheap, undeveloped shoreline nobody wanted, and spent 40 years turning it into the place my entire family's history happened. Every summer of my childhood, every 4th of July fireworks display we watched from that dock, my parents' wedding reception, held on that lawn in 1978, in photographs my mother still keeps framed in her hallway. My own wedding, 22 years later in that same spot. My father, Miguel Reyes, inherited the property from my grandfather, and when he died 11 years ago, left it in his will to be divided equally among his 4 surviving heirs. My mother, Ruth, and the 3 of us kids. Me, my older brother Danny, and my younger sister Carol. The will specified, explicitly, that the property could not be sold without unanimous consent of all 4 owners. A provision my father, a careful, deliberate man who spent 30 years as a civil engineer, had insisted on precisely because he understood, even then, what shoreline property like this was becoming worth. And precisely because he wanted to make absolutely sure no single family member could ever unilaterally decide to cash out a piece of land that meant more to our family than its dollar value could ever capture. I want you to remember that provision, because it becomes the single most important fact in this entire story. Unanimous consent, required, in writing, in my father's own carefully drafted will. For 11 years, that arrangement worked exactly the way my father intended. We all used the property. We split the modest maintenance costs, the property taxes, the occasional repair. My mother lived in the farmhouse full-time until about 4 years ago, when her health made year-round independent living there impractical, at which point she moved into a small condo in Petoskey, closer to Carol, while the 4 of us continued sharing the property for summers, holidays, and the occasional weekend getaway. Danny, my brother, moved to Charlevoix full-time about 6 years ago, taking a job managing a marina, and became, by informal agreement, the person who handled the property's day-to-day upkeep, mowing, minor repairs, coordinating with the property tax office. It was a role that made practical sense, given his proximity, and one none of us thought twice about for years. I did not know, until that Facebook post in a Trader Joe's parking lot, exactly what that proximity and that informal trust had allowed him to quietly do. I remember the specific, disorienting sensation of reading that listing description 3 separate times before my brain fully processed what I was looking at. 6-acre Lake Michigan parcel. Our address, unmistakably, in the listing details. Photos, recent photos, taken within the last few weeks, based on the season and the state of the garden of our boathouse, our dock, the exact bend in the shoreline where I'd learned to swim. Under contract. Meaning someone had already agreed to buy it. Meaning a closing date already existed. Meaning this wasn't a hypothetical, someday conversation our family hadn't gotten around to having yet. It was already actively 12 days from becoming permanent and irreversible. I called Carol immediately, my hands shaking hard enough that I fumbled the phone twice before I got the call connected. Carol, did you know Danny listed the lake house? The silence on the other end of the line told me everything before she even spoke. What are you talking about? She said slowly, and I could hear, underneath the confusion, the same cold dread starting to build in her voice that had already fully engulfed mine. I sent her the listing. She called me back 4 minutes later, her voice tight and shaking. I just called Mom, Carol said. She has no idea what I'm talking about. She got confused, kept asking me why I was asking about the lake house, said something about how she already signed Danny's papers a while back, but she couldn't remember what for. Amanda, I don't think she understood what she was signing. I called Danny that same evening, trying and largely failing to keep my voice steady. Danny, I need you to explain to me what I just found on Facebook. There was a pause, not a shocked pause. I noted even in the middle of my own panic, but a measured one, the pause of someone who had, on some level, been anticipating this exact conversation and had already decided how he wanted to handle it. I was going to tell everyone once the sale was finalized, he said. I didn't want to deal with a bunch of drama over something that's already been legally handled. Mom transferred her share to me 2 years ago. I bought out your share and Carol's share through the estate distribution when Dad's estate finally settled the mineral rights dispute. You remember that whole mess, right? I used part of that settlement to buy you both out. It's all legitimate, Amanda. I have the paperwork. I did remember a mineral rights dispute connected to a small parcel of undeveloped land Dad had also owned, separate from the lake property, that had taken years to resolve after his death due to a title complication. I remembered, vaguely, some conversation, years earlier, about eventual distributions once it's settled. I did not remember agreeing to sell my interest in the lake house to Danny. I did not remember signing anything. I did not remember ever, in 11 years, having a conversation with my brother about buying out my share of a property my father's will had explicitly required unanimous consent to sell in the first place. Send me the paperwork, I said. Tonight, right now. Get it to you, Danny said. I've just got a lot going on with the closing, Amanda, so give me a few days. 12 days from closing, and my brother was asking for a few days to produce documentation of a transaction I had no memory of ever agreeing to. I hung up the phone and called an attorney the next morning. I retained a real estate and probate litigation attorney in Grand Rapids named Sandra Whitmore, who specialized, fortunately for the tight timeline we were now facing, in exactly this kind of urgent property dispute. Within 24 hours, using the property's parcel number from the listing, Sandra pulled the recorded deed history from the Charlevoix County Register of Deeds. What she found confirmed my worst fears and introduced a new, more specific horror. 8 months earlier, a quitclaim deed had been filed transferring my mother's 25% interest in the property to Danny, for what the deed listed as consideration of $10 and other good and valuable consideration. standard boilerplate language for a transaction that isn't, in reality, an actual arm's-length sale for fair market value, but rather a nominal transfer. The kind of deed language typically used for gifts between family members rather than genuine purchases. 6 weeks after that, a second quitclaim deed had been filed, purporting to transfer my 25% interest and Carol's 25% interest to Danny as well, using the same nominal consideration language, bringing Danny's total recorded ownership interest in the property to a full 100%. Both deeds bore signatures. My mother's signature on the first. Mine and Carol's on the second. Neither Carol nor I had ever signed anything. "I want to be very clear about what we're looking at," Sandra told us, in an emergency video call 3 days after I'd first seen the Facebook listing, with Carol joining from Petoskey and me from Grand Rapids. "If your signatures on that second deed are forged, which based on what you're both telling me seems overwhelmingly likely, then Danny does not have valid legal title to your interests in this property, regardless of what the county's recorded documents currently show. But recorded deeds carry a presumption of validity in Michigan, which means we don't have 12 days to leisurely prove fraud through ordinary channels. We have 12 days to get an emergency court order preventing this closing from happening at all, while we build the case to unwind the fraudulent transfer properly. We actually do that in 12 days?" I asked, my voice barely steady. "We can try," Sandra said. "Michigan courts can issue an emergency temporary restraining order to prevent an imminent, irreparable harm, and the permanent loss of family real property through a fraudulent conveyance, especially property with the kind of sentimental and historical significance you've described, generally qualifies. But we need to move today. Not tomorrow. Today." Sandra filed an emergency motion for a temporary restraining order in Charlevoix County Circuit Court the next morning, seeking to halt the pending closing on the property pending a full investigation into the validity of the quitclaim deeds, supported by sworn affidavits from both me and Carol stating, unequivocally, that neither of us had ever signed any document transferring our interests in the property to Danny, and that we had no knowledge of any such transfer occurring until discovering the Facebook listing days earlier. The court, recognizing the genuine and imminent risk of irreparable harm, a piece of real property, once sold to a third-party developer with plans to demolish the existing structures, cannot simply be undone, the way a financial transaction sometimes can, since the specific physical building and land my family's history was tied to would, quite literally, cease to exist in its current form, granted a temporary restraining order 6 days before the scheduled closing, halting the sale pending a full evidentiary hearing. I want to describe what those 6 days felt like, waiting for that ruling, because I think it's important for anyone watching this who might someday find themselves in a similarly urgent, time-pressured family dispute to understand. There is a very specific, exhausting terror to fighting for something on a countdown, knowing that unlike most legal disputes, where delay simply means frustration and expense, this dispute had a hard, immovable deadline after which the thing you were fighting to save would be permanently, irreversibly gone. I did not sleep well during those 6 days. I called Sandra's office more times than I probably needed to, checking on status, asking whether there was anything else I could do. I drove up to Charlevoix myself, 3 days before the original closing date, and sat on the dock at the lake house, a property I technically, legally, at that exact moment, no longer had any recorded ownership interest in, at least according to the county's records. And I thought about my grandfather building that boathouse with his own hands, about my father's careful, deliberate insistence on the unanimous consent provision, precisely because he understood, even decades ago, what this land might someday tempt someone to do. While the restraining order bought us critical time, Sandra moved immediately to build the actual fraud case, Hearing the same category of expert, I'd later learn several other stories on this channel had also relied on a forensic handwriting examiner. In this instance, a Michigan-based analyst named Dr. Priya Chandrasekaran, who specialized specifically in real estate fraud and deed forgery cases. Dr. Chandrasekaran's analysis, completed on an expedited basis given the court's compressed timeline, compared the signatures on the second quitclaim deed, the one purportedly transferring my interest in Carol's interest to Danny, against multiple verified authentic samples of our actual signatures, gathered from tax returns, bank documents, and in a detail I found almost unbearably poignant, old birthday cards Carol and I had each sent to our mother over the years. Preserved in a box my mother had kept in her Petoskey condo, her findings were unambiguous. Both signatures showed clear, structural inconsistencies with our genuine handwriting, inconsistent pen pressure, unnatural letter formations, and in my own signature specifically, the complete absence of a distinctive small flourish I've unconsciously added to the final letter of my last name since high school. A habit so automatic I hadn't even consciously known it was part of my real signature, until Dr. Chandrasekaran pointed out its absence from the forged version. The notary who had stamped both deeds turned out to be a woman named Sheila Portnoy, an old family friend of Danny's from his years working at the marina. Someone Carol and I both vaguely recognized as an occasional presence at Danny's holiday parties over the years, but not someone either of us had any independent relationship with, and certainly not someone we had ever appeared before, in person, to have our signatures notarized. Under questioning from Sandra's investigator, a former Charlevoix County Sheriff's deputy named Robert Vance, Sheila Portnoy eventually admitted that she had notarized the second deed based entirely on Danny's assurance that Carol and I had already signed it and simply couldn't be present in person because they live out of town. A claim that, as Robert pointed out to her directly, is not a legally valid basis for notarization under Michigan law, which requires the signer's physical presence and personal appearance before the notary at the time of signing. The situation with my mother's signature on the first deed was, in some ways, even more troubling than the outright forgery on the second, because unlike Carol's and mine, my mother's signature on the first deed appeared to be genuinely hers, a finding Dr. Chandrasekaran confirmed after comparing it against verified samples. This meant the legal question wasn't forgery, in my mother's case, but something the law treats somewhat differently and, in certain respects, considerably more complicated to prove. Undue influence and lack of capacity. Sandra requested my mother's medical records, with her consent, obtained through a conversation Carol handled carefully and gently, given our mother's fragile emotional state throughout this entire ordeal. What those records revealed was that my mother had been formally evaluated by her primary care physician roughly 4 months before the date on the first quitclaim deed, and diagnosed, at that appointment, with what her doctor's notes described as mild to moderate cognitive impairment, likely early-stage vascular dementia, with documented difficulty in short-term memory retention and complex decision-making capacity. Danny had been present at that appointment. According to the doctor's own notes, he had driven our mother there and sat in on the entire consultation. 4 months later, he had, according to the deed's own recorded date, obtained her signature transferring her quarter interest in a property worth, according to the developer's own purchase offer, over $2.3 million, using nominal consideration language suggesting no actual payment had changed hands. From a woman whose own doctor had already documented significant difficulty with exactly the kind of complex financial decision-making that transferring a multi-million-dollar real estate interest would require. I want to pause here and address something directly, because I think it's important for the integrity of this story. I do not know, and I want to be honest that I will likely never fully know, exactly what Danny told our mother in the moments before she signed that first deed. I don't know if he explained clearly what she was signing, and she simply couldn't retain or process that information given her cognitive state, or if he deliberately minimized or misrepresented what the document actually did. What I know, based on the medical records and the timeline, is that our mother's own doctor had already documented, in writing, 4 months earlier, that she was not reliably capable of the kind of complex financial decision-making this transfer required, and that Danny, who had been present for that exact diagnosis, obtained her signature on a multi-million-dollar property transfer anyway. There is one more party in this story I haven't fully introduced yet, and their role turned out to matter more than any of us initially anticipated. The buyer, a development company called North Shore Ventures, LLC, planning to demolish the existing structures and construct an 11-unit luxury condominium project on the property. Sandra's investigation revealed that North Shore Ventures had been in discussions with Danny about the property for nearly a year before the fraudulent deeds were ever filed. Meaning, Danny had been actively negotiating the sale of land he did not solely own to a sophisticated commercial buyer for the better part of a year, while our family remained completely unaware any sale was even being contemplated. This detail became legally significant for a reason I hadn't fully appreciated until Sandra explained it. Michigan law, like most states, provides some degree of protection to a bona fide purchaser who buys property in good faith without knowledge of an underlying fraud, relying reasonably on the county's recorded title. If North Shore Ventures could establish that they had no reasonable way of knowing the deeds were fraudulent, and had proceeded in good faith reliance on the county's clean title records, unwinding the sale entirely, even after establishing fraud on Danny's part, could become considerably more legally complicated, potentially leaving my family with a claim for damages against Danny, personally, rather than a clean path to simply recovering the actual property. Sandra's investigator, digging into the negotiation history between Danny and North Shore Ventures, found something that complicated the developer's innocent purchaser position considerably. Email correspondence, obtained through a subpoena once litigation formally began, in which Danny had explicitly told North Shore Ventures' lead negotiator, nearly 6 months before the deeds were filed, that he still needed to finalize the ownership situation with my siblings before the sale could proceed, language that, Sandra argued, put the developer on reasonable notice that Danny did not yet have clear, sole title to the property, and that they therefore could not credibly claim to have relied, in good faith, on a title history that Danny's own prior communications had already called into question. The full evidentiary hearing, addressing both the temporary restraining order's continuation and the underlying fraud claims, took place over 4 days in Charlevoix County Circuit Court, roughly 6 weeks after the original scheduled closing date. 6 weeks during which the property remained frozen, unsold, under the court's continuing restraining order, while both sides prepared their full case. Dr. Chandrasekharan testified about the forensic handwriting analysis, methodically walking the court through the specific inconsistencies distinguishing the forged signatures from our genuine ones. My mother's physician testified about the cognitive impairment diagnosis and its documented timeline relative to the first deed's signing date, explaining, in careful clinical language, why a diagnosis of that severity would reasonably call into question a patient's capacity to understand and consent to a complex, high-value property transfer. Sheila Portnoy, the notary, testified, reluctantly, under subpoena, about notarizing the second deed based solely on Danny's assurance rather than our actual presence. A clear and, Sandra argued, knowing violation of Michigan's notary requirements that undermined any claim the second deed could be treated as validly executed. Carol and I both testified about discovering the sale through a stranger's Facebook post, about our complete lack of knowledge of either deed's existence prior to that discovery, and about the specific, painful history the property held for our family testimony that, while not itself legally dispositive of the fraud question, Sandra believed helped the court understand the full weight of what was actually at stake beyond the dollar figures involved. Danny testified in his own defense, maintaining, throughout, that he had genuinely believed our mother's signature reflected her real wishes, that he had always intended to eventually compensate Carol and me for our shares, once the sale went through, and that he had never specifically told either of us he'd forged our signatures because he'd assumed, given years of us not actively using the property as much as he did, that we would ultimately consent to a fair buyout if he simply presented it as a completed transaction rather than opening it up to what he called months of arguing about it beforehand. The presiding judge did not find that explanation legally sufficient, noting, in her eventual written ruling, that Danny's own testimony effectively admitted he had proceeded without our actual consent precisely because he anticipated we would object, and had chosen to forge our signatures specifically to avoid that objection, rather than have the difficult, honest conversation the situation actually required. The court voided both quitclaim deeds in their entirety, the forged second deed as an outright fraud, and the first deed, involving our mother's genuine but likely incapacitated signature, as invalid due to lack of demonstrated capacity and the strong circumstantial evidence of undue influence given Danny's documented presence at the diagnosis appointment just months before obtaining her signature on a multi-million-dollar transfer. Ownership of the property reverted to its original configuration under our father's will, equal quarter shares held by my mother, Danny, Carol, and me, with the unanimous consent provision fully intact and enforceable, meaning any future sale would require, exactly as my father had insisted 11 years earlier, agreement from all four of us. The court also found, regarding North Shore Ventures, that the email correspondence Sandra's investigator had uncovered was sufficient to defeat their claim to good faith bona fide purchaser status, voiding the purchase agreement entirely and leaving the developer with, at most, a potential separate claim against Danny personally for any losses they'd incurred in reliance on a deal that should never have proceeded on the terms he'd represented to them. Danny was not criminally charged in the immediate aftermath of the civil ruling. Sandra explained that the Charlevoix County Prosecutor's Office, while reviewing the case, ultimately determined that pursuing criminal forgery charges against a family member, given the civil resolution already achieved, and the complicated, sympathetic circumstances involving our mother's genuine but incapacitated signature on the first deed, was not their priority, though the referral remains on file and could, Sandra noted, still be revisited if additional evidence of intentional fraud emerged. I want to spend real time on what happened with my mother in the aftermath of this ruling, because I think it's the part of this story that has stayed with me the longest, longer even than the anger I felt toward Danny throughout the litigation. My mother's cognitive decline, once we finally had her more formally and thoroughly evaluated in the months following the hearing, was more advanced than any of us, including, I believe genuinely, Danny had fully appreciated before this entire ordeal forced the issue into the open. The specialist Carol found for her, a geriatric neurologist in Petoskey, diagnosed her with moderate vascular dementia, a diagnosis that, painfully, meant our mother would likely never again have the legal capacity to make major financial decisions independently, a reality none of us had wanted to confront directly until a fraudulent deed forced our hand. Carol and I, working together with Sandra, petitioned the court to establish a formal guardianship and conservatorship arrangement for our mother, not driven by any punitive impulse toward Danny, though I won't pretend some part of that instinct wasn't present in the early, angriest weeks of this ordeal, but out of a genuine recognition that our mother needed protection none of us had adequately provided her before this crisis exposed exactly how vulnerable her situation had become. The court appointed Carol and me as co-conservators, with Danny explicitly excluded from any formal decision-making role regarding our mother's finances going forward. A condition Sandra argued for directly, given the demonstrated history, and one the judge granted without significant hesitation given everything established at the earlier hearing. My mother, in the clearer moments she still has expressed real grief about what happened, not primarily about the property, I think, though that grief exists too, but about the fracture in her family that the whole ordeal exposed and deepened. "I just wanted my children to get along," she told me once, in one of her more lucid afternoons, sitting in her Petoskey condo. "I don't understand how it got to this." I didn't have a good answer for her in that moment. I still don't, fully. I told her, honestly, that it wasn't her fault, that whatever confusion led her to sign that first document, the fault for everything that followed belonged entirely to the person who chose to exploit that confusion rather than have an honest conversation with the family he claimed to be protecting the property for. Danny and I have not spoken since the ruling, beyond a handful of strictly logistical exchanges related to the property's ongoing shared maintenance, which, per the court's order, continues to be split, as it always was supposed to be, among all 4 legal owners. He moved out of the area roughly 8 months after the ruling, not, as far as I know, under any legal compulsion to do so. But I suspect, based on a conversation I had with a mutual friend still connected to the Charlevoix Marina community, that the fallout from the case, which became something of a locally known story once the court records became public and a regional newspaper ran a brief piece on the dispute, made staying in a small town where everyone had heard some version of the story considerably less comfortable than starting fresh somewhere his history wasn't quite so publicly known. Carol has had more contact with him than I have, cautious and limited, mostly centered around logistics related to our mother's care. Since Danny, whatever else is true about what he did, remains her son and has expressed, according to Carol, genuine remorse in at least some of their more recent conversations. I have not yet found my own way to a place where I can engage with that remorse, if it's sincere, in any meaningful way. I don't know if I ever will. I've made peace, mostly, with not knowing, and with allowing that to be an open, unresolved question rather than forcing myself toward a forgiveness I don't yet genuinely feel. I want to end with something that isn't about the fraud, or the litigation, or the complicated grief of a broken relationship with my brother, because I think it's the truest measure of what this entire fight was actually for. 2 summers after the ruling, Carol, my mother, in one of her better periods, present enough to genuinely enjoy the day, even if she needed help remembering some of the specific history being celebrated, my own kids. And Carol's family gathered at the lake house for the 4th of July, the way our family had for over 60 years, on the same dock my grandfather built, watching fireworks over the same stretch of Lake Michigan's shoreline that a developer had 26 months earlier. Been 12 days from permanently bulldozing into 11 luxury condominiums. My son, 7 years old, asked me that evening why the boathouse had a slightly different color of wood on one section of the roof than the rest. "Your great-grandpa built this whole thing with his own hands, a long, long time ago," I told him. "That part got a little worn down over the years, so we had to fix it up a bit. But it's the same boathouse. Just a little bit repaired, here and there, the way old, important things sometimes need to be." I didn't tell him, that evening, the full story of exactly how close that boathouse had come to not existing at all by the time he was old enough to remember it. He'll learn that story eventually, the way I've learned over the past 2 years to tell it, not as a story primarily about betrayal, though betrayal is undeniably part of it, but as a story about what it actually takes to protect the things that matter, when someone you love decides those things are more disposable, more negotiable, than you ever imagined they could be to the people who are supposed to love them too. If you're watching this and your family owns something together, land, a business, a vacation property, anything held jointly among siblings or across generations, I want to say something directly to you, informed by everything this fight cost my family to learn the hard way. Check the county recorder's records for jointly owned property, periodically, even when nothing seems wrong. It takes 10 minutes and costs, in most counties, either nothing or a nominal fee, and it is the single fastest way to catch exactly the kind of quiet, unauthorized transfer that very nearly cost my family 60 years of shared history. In the span of a Facebook listing, I happened to scroll past at exactly the right moment. If one sibling has taken on primary day-to-day responsibility for managing shared property, make sure that responsibility never quietly, informally expands into unilateral authority over decisions the rest of the family never explicitly delegated. Proximity is not the same as ownership. Convenience is not the same as consent. And if an aging parent's cognitive capacity is declining, even gradually, even before anyone's ready to use words like dementia out loud at the family dinner table, get a formal capacity evaluation on record sooner rather than later, and consider, seriously, a properly structured conservatorship or power of attorney arrangement with real oversight, before that vulnerability becomes something someone else decides to quietly exploit. My family got 12 days of warning, purely by chance, because I happened to scroll past exactly the right Facebook post at exactly the right moment. I think about, often, how easily that 12-day warning could have been 0 days. How easily this story could have ended not with a courtroom victory, but with a bulldozer, and a stretch of Lake Michigan shoreline my grandfather built by hand, gone permanently before any of us even knew it had been sold. Don't leave your family's protection to chance the way mine very nearly did. Check the records. Ask the questions. Watch closely, especially when everything seems fine. My name is Amanda Reyes, and this has been another family hidden fight. If this story reminded you of property, a business, or anything your own family holds jointly, share this with them today, and tell us your own story in the comments. It might become a future episode. Subscribe for a new family hidden fight story every week, and we'll see you in the next one.